S. Chan presents educational video lectures as per the new UGC curriculum. Difficult concepts made easy. Study anywhere, anytime.
So today I am here to talk about the classification of contracts. Before moving to the topic, I would like to recapitalize the last video in which we have discussed about the fundamentals of the contract and Indian Contract Act 1872. So we'll connect the same slide with the next slide, and the today's slide is classifications of contract.
If you want to study this topic in detail, refer to the book by S. Chan Publishing and Vikas Publishing House. Link is provided in the description box.
So let's begin. My name is Mohit Kapil and I'm here to teach you a business regulatory framework. Classification of contracts. The contracts are classified on 4 different bases. The number 1 is initiation. The second one is enforceability, which I have already gone through it. The third one is the formation of the contracts, and the last one is the performance of the contract. So according to the initiation, the contracts are classified as follows. The number 1 is unilateral contract. Do you know what is the meaning of unilateral? Unilateral means one way. So unilateral contract is also known as one-way contract. Let us have the definition of that. Let us understand the meaning of unilateral contract. A unilateral contract is an agreement where first party promises to perform a specific action upon the occurrence of a certain event, and the other party is not obliged to reciprocate the same. Let us understand this particular topic with the help of an example. For example, Mr. A is offering a reward for finding his car as a lost item. So here, if Mr. X found that car, it means Mr. A has performed a unilateral contract with Mr. X. I hope this example makes you clear what is a unilateral contract. Under the same type, we have the another type of contract, and that is bilateral contract. Bilateral, you know what is the meaning of bilateral? Bilateral means where the two people are involved in it. It involves an agreement where both the parties make promises to each other, such as buyer and seller. Let us understand the bilateral contract with the help of an example. Mr. A, let's say Mr. A promises to pay and Mr. X promises to deliver those goods. So between A and Mr. X, that forms a bilateral contract. Let me repeat the example once again so that you can understand the topic clearly. Mr. A promises to pay when they both are in a contract, and Mr. X promises to deliver that contract. That forms a bilateral contract. So in this particular slide, we have been talking about the classification of contracts based on initiation, and based on this initiation, we have classified the contracts into 2 types. The first one is unilateral contract, where the other party is not obliged to reciprocate, and the second one is bilateral contract, where the both parties have to perform their duties and roles and their obligations. Let us move to the next slide. Now the classification is according to the enforceability. According to the enforceability, contracts are classified as follows. Number 1, valid contract. Please make a note of it. This particular type is very important to understand. In order to run your business organization, in order to prevent your business commercial transactions, you should understand what is a valid contract. A valid contract is the one that fulfills all the essential elements of a contract prescribed by Indian Contract Act 1872. Let me recapitalize what were those essential elements. Number 1 is 2 or more parties. Number 2, valid considerations. Number 3, lawful considerations. Number 4, free consent and mutual consent, etc. Let us take an example of a valid contract. When Mr. A, with reference to the last slide, we can also refer the last example to make it clear. Mr. A promises to pay and Mr. X promises to deliver that good, that they, in that particular example, they both are fulfilling their conditions, and that that fulfillment makes a clear agreement between both the parties, and that is forming a valid contract. Now we have the second type of contract here, and that is void agreement. It is an agreement that is not enforceable by law. Whenever you found an agreement which is not enforceable by law, that is always known as a void agreement. This is the second type. Now moving to the third type, voidable agreement. A contract that is initially valid. Please make a note of it. A contract that is initially valid but can be avoided or cancelled by a defaulting party due to certain situations, that forms a voidable agreement. Let us understand this particular concept with the help of an example. If the consent, let me highlight here, if the consent of one of the party has been obtained through undue influence, if the consent of one of the party has been obtained through any undue influence or coercion or any fraud or you can say misrepresentation, that is known as voidable agreement. Now the fourth point is void contract. Void, what does it mean? We have been talking about void agreement, we are talking about voidable agreement, now we are talking about void contract. So we should know what is the term void here. Void means not binding legally. I hope the point is clear to you. Void means not binding legally. It means it is a useless contract which has no legal effect, and such contracts are always known as null and void. So according to the enforceability, the contracts are classified in 4 different ways. The first one is valid contract, the second one is void agreement, the third one is voidable agreement, which is also known as a contract, and the fourth one is void contract. Let me tell you what is void here. I am just recapitalizing it. I am just reiterating it. Void means not binding legally. Let us move to the next slide to make it more clear. Classification of contracts. Let me tell you, we have been continuing this topic. So a contract becomes void as soon as it ceases to be enforceable by law. So a contract becomes void when it is ceased by, and I mean when it ceases to be enforceable by law. Such contracts are valid in their beginning. Whenever you form a contract, they are valid in their beginning, but subsequently they become unenforceable by law, and hence they become void contracts. I repeat, they become void contracts. Let us discuss a few reasons why such transformations are there. I mean, what are the reasons which actually transforms a valid contract to a void contract? Let us understand. The first reason is supervening impossibility. Before understanding this topic, you should know what is the meaning of supervening. Supervening means something which has happened in the middle of an event, or something which is unforeseen to us, something which is uncontrollable to us, which is not in our hands, and those things always happen in the middle of a situation. So that is a supervening impossibility. Supervening means something which has happened in the middle of an event. Therefore, a contract becomes void by impossibility of performance after the formation or execution of a contract. I am sure you must have not gone through this particular thing, but yes, the below example will definitely make you clear what is the supervening impossibility. For example, Mr. A and Miss B, they enters into a contract to marry with each other. But before the time fixed for the marriage, Miss B got mad. She got mad. Therefore, this valid contract becomes a void, because Miss B is unsound mind and Mr. A cannot marry an unsound person. So I hope this particular topic is clear to you. Something which has happened here, and this is a supervening impossibility, which was unforeseen, which was uncontrollable to both of them. I hope the topic is clear to you. So in this particular slide, we have discussed about the reasons here. This was the first reason, supervening impossibility. Let us move to the next slide so that you can understand the another reason. The second reason is subsequent illegality. What does it mean? A contract may sometimes become illegal because of the contingent situations. May I know what do you understand by contingent situations, which are always not in our hands, which actually happens in between something, in between the events, which are actually not known to us. So we can understand the same concept with the help of an example here. And let me tell you, these examples will definitely make you clear each and every topic related to the Indian Contract Act or related to the subject business regulatory framework. Mr. X here, Mr. X is a person who is agreeing to sell 200 bags of rice at rupees 500 per bag. But before delivery, please pay attention to this particular point. But before delivery, the government prohibited, or you can say the government banned to trade in rice. So now the contract has become void. So I hope you got the point here. We were talking about the voidable agreement, voidable contract. So these are the examples which actually transforms a valid contract to a void contract. The first one is supervening impossibility, and the second point is subsequent illegality, which has been cleared with the help of an example. Now this is the question time here. Mr. X, this is the question which is very exciting in nature. Please understand this point. Mr. X threatens to shoot Mr. Y if he does not sell his new car to Mr. X for rupees 2 lakh. So Mr. Y agrees here. Do you really believe that the contract has been brought about by coercion? I mean, can you identify the right answer here to justify this particular statement? So, in order to get the answers, please stay connected with us. Here, we'll take a break of 5 minutes and then we'll meet after some time.
Now quality learning is easily available at your doorstep. S. Chand Academy brings detailed lectures based on UGC curriculum as per the New Education Policy 2020. So do not forget to subscribe to the S. Chand Academy and access the wide world of knowledge conveniently sitting within the comfort of your home. Stay connected and keep watching S. Chand Academy. Happy learning!
So welcome back to the S. Chand Academy. We were talking about the classification of contracts, and we were on the last slide. Before break, we had a discussion regarding the last question here. Let me get back to the question here. So this was the question here. In order to get the answer of this question, please stay connected with us. Meanwhile, let us move to the next slide. Okay. So, concerning the classification of contracts, there is another classification, which is formation. So, according to the formation, the contracts are classified as follows. The number one is express contract, which is the very simple contract, very simple to understand. An express contract involves both express offer and express acceptance. May I know, what do you understand by the term express? How do we express ourselves? That is the literal meaning of this particular word, express. An express contract involves both express offer and express acceptance, where you are expressing something to the another person, and that constitutes an agreement which forms a valid contract, but either in written or by spoken words. So let me highlight here something. Written or by spoken. So whenever you enter into a contract either in written form or by spoken words, that leads to an express contract. Such as, for example, if you are talking about a will, if you are talking about a sale or purchase of a property either in written or by spoken words, that forms an express contract here. The second type is implied contract. So you are a BCom student. Okay, and I believe that you know the meaning of the word implied here. Implied means something which has already been implied to us. Let us take an example here. An implied contract involves both implied offer and implied acceptance, which actually constitutes an agreement which forms a valid contract. Valid contract, but by the conduct of parties or circumstances arisen at that time. I am definitely sure you will get impressed by this particular contract here, because generally we enter into such type of contracts unknowingly or knowingly. For example, Mr. X is a professional shoe polisher, or you can say Mr. X is a professional shoe shiner. He starts shining the shoes of Mr. Y without being requested by to do so. I repeat, and I am emphasizing here, Mr. Y, Mr. X, a professional shoe polisher, starts shining the shoe of Mr. Y without being requested by to do so. Then here the law applies that Mr. Y will definitely pay to Mr. X, and there is an implied contract because Mr. Y did not deny to whom to not to polish his shoes. I hope this example makes you clear the term implied contract. So according to the formation, according to the classification of the formation, the contracts are classified into multiple categories. The first one is express contract and the second one is implied contract. Let us move to the next slide here. Now according to the formation, the third type of contract is quasi contract. Guys, this is literally very important to understand what is a quasi contract. It is a contract which is neither expressed or nor implied. If we are talking about expressed and implied here, we have already gone through it. We know what is an express contract, we know what is an implied contract, but we don't know what is a quasi contract. So a quasi contract is a contract which is neither expressed or nor implied, but it arises due to legal prescription designed. It arises due to legal prescription which is designed to prevent unjust enrichment despite the absence of actual consent, actual contract. Let us take an example to make it clear. For example, if someone is providing emergency services without any prior agreement, that is a quasi contract. I am sure you will definitely get clear understanding about this particular contract by understanding the second example. So example 2 is a packet of bread delivered to wrong addressee Mr. X, and now Mr. X is under an obligation either to pay for the bread or to return it. So that particular contract makes a quasi contract between that particular courier man and between Mr. X. I hope the quasi contract is clear to you. So let us recapitalize what is quasi contract. A quasi contract is a contract which is neither implied, which is nor expressed by a person, but it arises due to legal prescription which is designed just to prevent unjust enrichment despite the absence of actual consent. So there was no actual consent between the courier man and the Mr. X. So Mr. X and Mr. X and courier man was not having any consent between them. So that is why this is known as a quasi contract. Let us move to the next slide to understand the another classifications of the contract. The third classification of the contract is performance. According to the performance, the contracts are classified as follows. The number one is executed contract. For example, a construction contract where the work has been completed and the contract has been fully discharged by exchanging considerations. Let us take an example here to make it more clear. Mr. A, he is a builder, and Mr. X, who is the one who is looking to construct his building. So Mr. A has constructed the entire building within the time frame and provided all the terms and conditions of a valid contract. So here we can say that both the parties have obligated their, both the parties have fulfilled their obligations and the expectations of each other. So this is known as executed contract. So let us understand the content of the executed contract here. An executed contract is the one in which the contracting parties, Mr. A and Mr. X, have performed their obligations, which means they have, Mr. A has constructed the building of Mr. Y, or say Mr. X, or Mr. X has paid something into the consideration to Mr. A. So under the executed contract, a contract should be fully discharged and the parties should be free from their respective liabilities. So I repeat, what are the respective liabilities are here? Mr. A was liable to construct the building and Mr. X was liable to pay a certain amount of money in exchange of that particular contract, or you can say that particular commercial activity. So I hope the executed contract is clear to you. Now let us move to the next one, which is almost similar to each other, similar to the executed contract. What is that? The next point is executory contract. It is an agreement where both the parties not yet fulfilled their obligations. Let us refer to the last example where Mr. A was a builder and Mr. X was the a person who was looking to construct his building. If suppose a construction the example is a construction contract where the work is still in progress. It means if Mr. A is still in progress to construct that building and Mr. X is still waiting to have the construction of that building. So here we can say the contract between these two parties are executory contract. I hope this slide is clear to everyone. So according to the performance, the contracts are classified accordingly. The number one is executed contract and the second one is executory contract. So before ending this video, let us have the answer of this question. Mr. X threatens to shoot Mr. Y if he does not sell his car to Mr. X for rupees 2 lakh and Mr. Y agrees on that. So the contract has been brought by about. Any guesses? Let us guess the right answer. The right answer is coercion here. Is that clear? I hope the point is clear to you. So if the contract has been done, if the contract has been brought about by any coercion or under influence or mutual, if it is not mutual consent, if there is a fraud in a contract, then that contract is not enforceable by law and which is not a valid contract, and that option Y, that is a voidable contract.
If you want to study this topic in detail, refer to the book by S. Chand Publishing and Vikas Publishing House. Link is provided in the description box. If you found our video interesting, please like, share and subscribe. And do not forget to press the bell icon.
All rights reserved. This video has been prepared for educational purposes only. No part of it may be reproduced or copied without the permission of the copyright holder.